Hi everyone, welcome to another episode of TaxSnax. Today we're going to be talking about the recent judgment in a Taxpayer versus HMRC, which was given on the 13th of February and in the Court of Appeal, where the taxpayer succeeded. So the case concerned a taxpayer who claimed that she was not a UK resident for the 2015 and 2016 tax year, arguing that her extended presence in the UK wasn't due to exceptional circumstances under paragraph 2022-4 of Schedule 45 of the Finance Act 2013. The taxpayer had contended that the 6 days in which she remained in the UK were beyond her control and should not be counted towards the 45-day limit under the statutory test. And that was because those 6 days the taxpayer had spent caring for her sister, who was suffering from severe alcoholism and mental health issues. The HMRC had said that these did not form part of the exceptional circumstances, and so they should count. The first tier tribunal had actually allowed the taxpayer's appeal, but the upper tier tribunal rejected it on all grounds. So HMRC put forward 4 grounds of appeal at the upper tribunal. The ground one was that the FTT had erred in deciding that the requirement that the circumstances prevented the appellant from leaving the UK could be met by a moral or conscientious obligation. Ground 2 was that the FTT had erred in failing to apply each element of the statutory residence test to each individual day. Ground 3 was that the FTC's decision on exceptional circumstances was internally contradictory and perverse, and that the circumstances were not exceptional. Ground 4 was that the FTT erred in having found that there were exceptional circumstances in the appellant case. They failed to consider whether those circumstances applied satisfied the remaining elements of the statutory test, and the UT therefore allowed the HMRC's appeal on all grounds and set aside the FTT's decision. And they essentially concluded that the circumstances of the visits were not exceptional and the appellant was not prevented from leaving the UK on any of the 6 days in question by exceptional circumstances, and so they were a tax resident for the purposes of the tax year 2015 to 2016. The appellant appealed this, and this went all the way to the Court of Appeal, which allowed the appeal on all grounds put forward. The appeal was obviously, taxpayer's argument was based on the paragraph 22.4, and on the wording of this, there are 5 conditions, all of which need to be fulfilled in order for paragraph 22.4 to apply, and this has been common ground throughout all the hearings in the different the upper tribunal and the FTT, and they're as follows. So the circumstances ought to be exceptional, the circumstances ought to be beyond P's control, P would not be present at the end of the day but for those circumstances, and the circumstances prevent P from leaving the UK, and the person intends to leave the UK as soon as the circumstances permit. So, as I stated, the Court of Appeal overturned the upper tribunal's decision on the key points, and there were 6 grounds of appeal which were submitted by James Kessler KC and Rebecca Sheldon, who represented the taxpayer. There was a ground 2 which was not pursued further because it was unnecessary for the appeal, so I'll just go through all of the grounds from ground 1 to 6, leaving out ground 2. So ground 1 was that the upper tribunal erred in its approach to the test as to whether the appellant was prevented from leaving the UK. So the upper tribunal was wrong to hold, it was submitted, that a person must be physically or legally unable to leave in order to be considered prevented under paragraph 22.4 of Schedule 45. And there's a long discussion of what that word means in this context within the judgment. Paragraph 55 of the judgment says that it's accepted that ground 1 of the appeal is well-founded. The upper tribunal was wrong, in my judgment, to hold that the FTT erred in saying that moral inhibitions could not be what prevented P from leaving the UK. the court addressed concerns about subjective moral obligations, noting that a taxpayer staying to care for a pet tortoise or to a cup final, that would not qualify as an exceptional circumstance. And the FTT, so the Court of Appeal's judgment concluded that the FTT correctly held that moral or societal obligations can realistically prevent someone from leaving even if they're not physically trapped. And the UT's view was too narrow of the word prevention, and the Court of Appeal hence allowed this ground and ruled that prevention does include circumstances where the person has no real choice but to remain. As I said, ground 2 was not pursued. And then we have ground 3. So the upper tribunal erred in holding that whether circumstances were exceptional was a matter of law. So in paragraph 68, we have the judgment, which states, Mr. Kessler submits that the UT was wrong about this, and that whether the circumstances were exceptional was indeed a question of fact. And then the judgment concludes in paragraph 78, after the survey of the relevant authorities, I think the position in the present case can be summarized quite briefly. The meaning of paragraph 22.4 is like any other question of statutory conjunction, a question of law. But there is no reason to think that the exceptional circumstances in that paragraph has any special meaning. It is a matter for the FTT as the fact-finding tribunal to consider whether the circumstances as found by them do or do not qualify as exceptional. This is also a question of fact, albeit one of evaluation or assessment rather than of primary fact. The UT can only disturb their conclusion on this if it involves an error of law. That can be shown in accordance with the Edwards and Barstow principles if the quotation, true and only reasonable conclusion, end of quotation, contradicts their determination. And then the judgment goes on to say, paragraph 79, in those circumstances, I accept Mr. Kessler's submission that the UT went too far in saying that, quotation, whether one or more of the findings of fact mean that the taxpayer's circumstances were exceptional is a question of law. And so ground 3 was successful. In ground 4, it was submitted that the UT had erred in holding that moral obligations cannot be part of the exceptional circumstances. And so if someone has no real choice but to remain in the UK due to a moral duty, that ought to qualify under the laws submitted. Paragraph 63 of the judgment says, in my judgment, therefore, the moral or societal obligations which the illness of a relative or any other situation imposes on P form part of the overall circumstances and can and should be taken account of in considering whether the circumstances as a whole qualify as exceptional. I would therefore accept that the ground 4 of the appeal is well founded. So the court ruled that moral obligations can be part of exceptional circumstances. And then we had ground 5. It was submitted there that the UT had erred in holding that the FTT made contradictory findings on the exceptional circumstances issue. It was submitted that the UT had wrongly claimed that the FTT's decision was internally inconsistent. The FTT carefully assessed the facts and had reached a rational and justified conclusion. The court held that the FTT's decision was not perverse and was based on a reasonable evaluation of the evidence. So the judgment states, Mr. Kessler emphasized the findings of the FTT, which were in graphic terms, and this is quoting from the FTT's own decision, FTT at paragraph 182, a time of crisis, a dysfunctional household, incapable of caring for herself or her children, her sister and her children were unkempt, the house was filthy, and ending the quotations on the FTTs in the FTT. The FTT clearly thought this level of neglect and its consequences for the children was indeed something over and above the distress and suffering for the individual concerned and for the individual's family. In paragraph 86, the judgment says, that seems to me the only real sensible way to read these paragraphs together. It is well established that reasons for a decision can always be better expressed, but that judgments and decisions should be read on the assumption that judges and tribunals know what they are doing unless they have demonstrated to the contrary. In the same way, I think a decision such as that of the FTT here should be read on the assumption that the FTT intended to be rational, coherent, and consistent unless one is driven to the conclusion that it cannot be read, cannot be so read. So ground 5 by the taxpayer was also accepted. Then we had the last ground 6. Were the paragraph 22.4 conditions satisfied on each date? And it was submitted that the UT had wrongly claimed that there was no evidence to support the FTT's finding that the taxpayer was prevented from leaving on each of the 6 days. In paragraph 99, after going through all the evidence, after going through all the arguments, it was stated, in the end, I am persuaded that this was a case where it could not properly be said that the FTT had no evidence in support of their conclusions. They were placed in a difficult position once they had decided not to accept the appellant's evidence as to suicide risk. But I think there was sufficient material before them to conclude that the appellant intended to leave as soon as circumstances permitted, and the need for her to stay continued until she actually left on each occasion. That may be a generous conclusion in her favour, but the assessment of whether the circumstances prevented her leaving on each of the days in question and whether each of the other statutory conditions was fulfilled on each day was a matter for them, and I do not consider the UT was justified in concluding that they had no material on which to reach conclusion in her favour, and therefore the court ruled that the FTT had sufficient evidence and the UT should not have interfered. And that's just sort of a brief, quick go-through of the grounds. The judgment is around 27 pages. It's definitely worth a read to really go through each of the arguments and that was submitted under each ground to understand the submissions made. What does this mean for taxpayers? So it means it's quite an important judgment because the law is now going to be a lot more broadly interpreted, and it possibly is going to apply to a lot more people. Also, it gives a better interpretation of the meaning of the word exceptional, and it's more than just an interpretation, and it's not limited anyone, and it allows exceptional to really take into account what do count as actual exceptional circumstances, and the judgment is likely to affect many. So it's definitely one that's quite important right at the start of our year, and a one that's definitely worth read and understanding, as it's likely to affect many. Thank you for listening for this episode.